Justin Baldoni argues Me Too law doesn't apply to Blake Lively's fabricated harassment claims. Now, guys, we have been talking about this. I have actually, in two particular videos, I'll see if I insert a clip here, but there was one video when I first was going over the California, I guess is what 47.1 law that covers people who allege sexual harassment, that they can't have retaliation come against them, that they're protected under this law and that you can't retaliate. She's claimed that Justin Baldoni defending himself against her false claims somehow is retaliation, along with this untraceable, undetectable, invisible smear campaign. We're going to need Dora the Explorer to find this thing, but okay. So a lot of things have come out, guys. I'm going to try to catch you up in a bunch of videos today. But Ryan Reynolds filed his motion to be dismissed from the lawsuit, Justin Baldoni's lawsuit. Brian Freedman has responded to that. Now he's also responded to Blake Lively's attempt to dismiss Justin Baldoni. Justin Baldoni has responded to Blake Lively trying to get his lawsuit against her dismissed. And that's what we're going to cover today. There's also some things with Jed Wallace. Guys, it's a cluster. So we're going to try to dig through it. Stay with me today. Make sure you're subscribed and hit the notification bell. The majority of you guys have come over here, but the majority have not subscribed. So if you could do me a favor and do that, that really helps me out and lets me know I'm on the right track with the things that I'm talking about. Now, this goes into with him saying the Me Too law doesn't apply. I did two videos. I did one video where I explained and I talked about how that she did not meet the qualifications to be covered under that. Okay. And I specifically talked about malice and I talked about different things. And in fact, let's insert that clip. Now, I shared this yesterday and I kind of went over the different parts of this, but I want to go over it again for you guys who haven't seen it and how this again, we're just taking one little part right now, not even the entire case. But just as a lay person, because you guys know I am not an attorney, but this is my interpretation. And these are the things that I'm seeing, the receipts that I'm seeing and how I'm interpreting this. Now, we need Bryan Freedman to respond, and I cannot wait for it in a legal filing to actually respond to her for her filing to be dismissed, for this lawsuit to be dismissed. But look here, it says a communication made by an individual without malice regarding an incident of sexual assault, harassment, or discrimination is privileged under Section 47. There was malice, not only towards Sony, but Justin Baldoni and Wayfair Studios, because all of her actions in the evidence shows how she and Ryan Reynolds, tried to take over this movie, even lying to Justin Baldoni and saying that she wrote the rooftop scene, but then admitting on the red carpet that no, it was Ryan Reynolds, who he has no rights or authority to write anything. And I'm wondering why the Writers Guild has not come out and said anything, because if you are writing a scene for a movie, there's all types of legal hoops that you need to go through and to assign who has done what, giving credit to who, and all of that. But that is with malice to say you wrote the scene, and that is the belief and information that everyone on the film has. But then to find out, no, later, actually, he wrote it and I lied about it. Another action of malice, of deception, going behind Justin Baldoni's back, going behind Wayfair Studios, going behind Sony's back. And again, allegedly saying that if she does not get her producer credit, if she doesn't get her way, if her edit of the movie is not chosen, that she was going to file a sexual harassment complaint against them, threatening them. And, it also goes in to talk about, it says prevailing defendant in any defamation action brought against the defendant for making a communication that is privileged under this section shall be entitled. What communication did she do that was privileged? She took that CRD complaint in California of sexual harassment and she shared it with the media. She publicized it and then worked with them, which she does not deny, work with them in order to make that complaint public, therefore erasing the privileged, the notion of privilege here. When you think of attorney-client privilege, when you think of filing a complaint, your name as the alleged victim, it is not made public. It is not for public consumption. Those documents are kept private, also known as privilege. But she released them to the public in conjunction with the New York Times. Right? So doing that, and then we need to find out who else did she share it with, because we know in a coordinated effort at the same time, all of the other actors, or some of them who were in this film, well, they just automatically unfollowed at the exact same time, unfollows, or in the same period of time, the same day, unfollowed Justin Baldoni, and then talking about the New York Times article, read this, and being on her side. When you think about how did she share that with them? Were there group chats? Were there team meetings? It had to be coordinated, which shows malice. Was she bad mouthing him to other people and saying all of this stuff was happening to everyone but the proper channels? When you look at this, and there's a lot more to it, we can go into the reasonable basis, which she does not, and this ties into, if it was reasonable, why didn't she file complaints through the proper channels? And it has to be factual information, and this is where we're going to get to in a second, where the judge cannot determine what is factual. Okay, so this is one of the things, as I was reading through that law, I said, this doesn't apply to her because of these reasons. Then I did a subsequent follow-up based on Without a Crystal Ball. She does great analysis over there. Shout out to, I think her name is Katie. Great analysis. Just, she's not a lawyer. None of us are attorneys, but we're just as lay people walking through the evidence, seeing the filings, and trying to interpret it with our kind of layperson's mind. There are some lawyers that have jumped onto this case. I think Asked Two Lawyers, and then there's another gentleman, and then there's someone X like Leanna Newton and other places that you'll find. But by and large, LawTube has not picked this up yet. We can use your help, LawTube, to get different legal opinions. So we just have to wade through this the best that we can as regular people. So what I did was, she had a video that talked about how Blake didn't qualify for this under this law because she didn't, even though she filed for her civil rights complaint in California, she didn't follow up the EEOC. But then there was another thought, was that because she was actually an employee, I mean, she wasn't an employee, she was a contractor, that she would not qualify under there. And Katie pulled that out from just the filings that Justin Baldoni's attorney, Bryan Freedman, had put out. And he specifically says that she wasn't an employee. So based on that language, you have to understand, lawyers, especially Bryan Freedman, is not just putting something in there without reason. So with him hitting on that, it was like, okay, that's a signal to show that she doesn't qualify. And this could be one of their arguments of why her case entirely, it could possibly be dismissed. Doesn't mean they're going to file for it. And especially before discovery, I think they're going to go through discovery and depositions before they would even try something like that, or a summary judgment. But I alluded to that. But what's great now is that, and then there was a lot of dispute about it. People were saying, well, that's not true. She still could qualify as an employee because of this, that, and the other, because of previous case law. And she acted as an employee. But then I argued, and other people have argued, well, she actually took the role of boss. Like she controlled on that set, even Justin Baldoni's speech. And I would say even thoughts. She said, if there was even an attitude change, if there was anything, she could say that was retaliation. She got to choose who could say. She basically designated in that 17-point, return to work demands, that they then expanded to 30 points in their filing, which was a lie, did not exist. So the 17 return to work points, which mostly benefited her and gave her a huge control over the movie, that one of those things was she could control who could see the film, who could be in the editing room, who could be on set during different times, who could say what to each other. Like she effectively became in charge. And then we know the things with her getting the PGA credit and becoming a producer. And there's a lot that goes into it. But I'm glad now we have this, because it does give credence to the things that I've said before. And I think somewhat to what Without a Crystal Ball had to say. So now let's get into it. Justin Baldoni's lawyers responded Thursday to Blake Lively's attempt to throw out his defamation suit, arguing that a California law meant to protect harassment victims doesn't apply to Lively's fabricated claims. The actor-director filed a $400 million lawsuit against Lively and his co-star and her husband Ryan Reynolds in January, arguing that they set out to destroy his career and hijack his movie. It ends with us with false allegations of harassment on set. In a motion to dismiss the suit last month, Lively's team argued that her allegations, which were first made in a California civil rights complaint that was shared with the New York Times, are protected by litigation privilege. No, they're not. All right, there we go. Lively's lawyers also invoked the Protecting Survivors from Weaponized Defamation lawsuits, a 2023 law that protects harassment accusers from retaliatory defamation suits. The law provides immunity from suits and allows a prevailing defendant to claim attorney's fees and damages. In response on Thursday, Baldoni's lawyers noted that the protection applies only to harassment claims with a reasonable basis and that are made without malice. I called that out first, like before I even did the analysis of Without a Crystal Balls thing, which is kind of a separate argument. I called that out, which I played you guys that clip. And so that's what I was seeing. She does not qualify. Okay, because of this, because the reasonable basis she did not have, and then also without malice. I'm sorry, I just feel good. I'm not a legal mind, but when my slow brain actually is able to accomplish something, even though I didn't really accomplish anything, or at least figure something out, I feel good, guys. Okay. All right. Enough said. They argue that Lively, in fact, made up the allegations and that therefore the law does not apply. Lively fabricated her allegations of sexual harassment, either wholesale or by exaggerating benign and not harassing interactions, and a concerted malicious effort to seize control of the film, and later to restore her reputation after a well-publicized series of marketing missteps that sullied her reputation, Baldoni's lawyers argue. Baldoni's lead lawyer, Bryan Freedman, said in a statement that Lively's team is attempting to set a dangerous precedent by using the law to undermine Baldoni's right to sue under the First Amendment. Miss Lively and her circle of Hollywood elites cannot prevent my client from exercising their constitutional right to petition the court to clear their names from her false and harmful claims, Freedman said. This right protects not only Mr. Baldoni and the Wayfarer parties in this particular case, but all Americans in the future who have false accusations levied against them and seek relief from our justice system. This must stop here. And we will continue to fight against the blatant attempt to block access to the court system and to weaken our nation's constitution to serve those who are in the position of power. Woo! He said a word there. It's like in church. Woo! Okay. The response also contends that the litigation privilege does not apply because Lively first made the allegations well in advance of lodging a civil rights complaint. So, what that is referring to as well, we're going to get into more of it, but I just want to set this up. Leanna Newton, who goes by Kiara J 2002, she's also an attorney. I was the first to report of her findings. I had found an earlier date. So she filed her CRD complaint, the California Civil Rights Complaint, on the 20th of December. On the 21st, the article comes out in the New York Times, fully edited with pictures and this text message chain that was found out to be doctored. Then you also go and as I was looking at it, no one had been talking about there was a video that went along with it. So I dug into the metadata and I found the video from the New York Times where Megan Twohey, the godmother of Me Too, states that this is what really happened. She's stating for a fact that this is what happened to Blake Lively, that Justin Baldoni did this. But when I went to go look at it, the metadata all over the place said the date was 12/12, December 12th, even though the article came out on the 21st and her CRD complaint was on the 20th, right? So I found that earlier date of 12/12, and it was even in the video, the URL that actually had the 12/12 date in the URL, guys. So I had published that, and then someone let me know that Leanna had found the October 30th date in the metadata in the actual article, where they have the text messages that are out of order and I believe illegally obtained. That the thing that did the text messages, that was designed, that was done, those text messages, on October 30th. So that's when we find out that earlier date. Okay, guys. So they had been working on this for months in advance. All right, so let's continue now. Baldoni's team also cites an interview Lively gave at the 2022 Forbes Power Women's Summit, which they argue supports their contention that she intended to seize creative control of the movie. In the interview, Lively stated that when she was starting out as an actor, I knew that they wanted me to show up and look cute and stand on the little pink sticker where I'm supposed to go and say what I'm supposed to say. But I also knew that like that wasn't fulfilling for me, that I wanted to be part of the storytelling. And sometimes I would have people who really resented that because they were like, "We just hired you to be an actor," she continued. I wouldn't reveal that I actually need to have authorship in order to feel fulfilled. So I think that for them, sometimes that might have felt like a rug pull, because you're trying to assert yourself into something that we didn't hire you to do. I covered that when it came out. And the first person I was alerted to that talked about this was, I can never say her name. I'm just going to say her channel, Flossom. You know, the one, your congratulations on your little baby bump. I reported on that as well, and how she ended up, telling on herself essentially about this whole thing. Now, this they finish up by saying Baldoni's team argues this is exactly what happened on the set of It Ends With Us. This took place, guys, I believe 3 months before she was hired for It Ends With Us. So when she did that, when she spoke about doing the rug pull and really having malicious intention when she's hired as an actress, and this is something that she does, she tried to clean it up and say, "Well, I used to do that, but now I'm upfront with what I want, and I want authorship and control and all of that," which is not true. And so when you look at it, she confesses and says, "But this is what I usually do." But she tried to make it, you know how like you're confessing what you do, what you've done in the past. But now I try to be more upfront and try to say that I want all of that. Absolute lie. And we can see that through It Ends With Us. So she planned from the outset. What he's arguing was that she planned this months before she was talking about this, which they were probably in the talks during this time. You don't just like the day you get hired, that's when the talks began. Obviously, it takes a long time to get an actor on board for a project. So if she did this just a few short months, she said these things a few short months before she was hired, obviously this is the same state of mind that she has. This is what they're arguing. So this shows the malice and all of that within her and what she's doing and trying to accuse Justin Baldoni of. So hopefully that makes sense. There's a lot more to break down, guys. I'm going to be posting all through the weekend. Even if nothing else comes out, there's some things I got to catch up on. I want to get to and show you guys. I'm also working on some new merch. If you guys want to support me over here, it's a lot of work trying to dig in and find all these receipts. You can go to realmelanieking.com. I have my Team Justin merch. I always like to show you guys my Justice Dragon. These are all designed by me, exclusive limited edition designs. I'm actually about to put out another design this weekend, so stay tuned from that. And I also had to help Elsrich so that she can get her FAFO associates, F around and find out associates merch. So that was fun working on that with her or talking to her about that. But this is my Justice Dragon. Have it in a shirt, mug, double-sided pillow. I have it ends with court also with the mug, double-sided pillow, and shirts. So if you want to show support over here and help me out, you can check that out. And with that, I will see you guys on the next one.